Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that next time I test you and you test positive, it's just not going to go well for you. You understand? You've given your lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we are
Call DPS, you know,
because they're even
you
when they
can
run.
call DPS. Have I given you the phone number?
I don't think so, did I?
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria, sign a reset. You'll get with Felicia if your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to the husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her. He merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
All right, ma'am, I'm gonna find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just, Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart Asset Protection employee, and the complainant stated that he reviewed store surveillance, and on September 12, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02. And on September 18, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one-leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were 0.212 and 0.217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
Your Honor, we have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, ma'am. Okay. Morning, Mr. Please. I don't care where you live. I don't care what you do. You are still under bond condition of this court. If you do not have a Texas driver license, and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck.
There's a particular kind of courtroom moment that stays with you. And it happened right here. a woman stood before a judge on a false police report charge, and the sequence of events that led to that moment was almost too brazen to believe. She threatened on the phone, while an officer was listening, to call her husband's probation officer and say whatever she needed to say to send him back to prison. Then she called 911 with a domestic violence claim. When officers arrived and started asking questions, she said her husband pushed her, then said he only brushed against her, then denied ever making the call, then claimed dispatch misheard her, then denied making a statement to the officer at all, and then the officer played back the body cam. And she admitted, right there in the hearing, that she wasn't telling the truth. That collapse, 4 pivots, 1 body cam, is what courtroom accountability looks like in real time. No dramatic verdict, no courtroom outburst, just evidence and silence, and a judge who had seen enough. Surrounding that case was a morning full of defendants who made similarly miscalculated bets. A Walmart employee who skimmed the register 4 separate days across 4 days and thought no one was watching the surveillance footage. A woman so visibly drunk that a bar refused her entry, who then got behind the wheel anyway and blew more than twice the legal limit. And a 20-year-old who looked directly into a high school security camera and said, "Ready," before assaulting someone. What binds all of these moments together is something the judge said directly to one defendant: make better decisions. It sounds simple, but in that courtroom, on that morning, it landed like a verdict all on its own. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.